Well, hello everyone, and welcome to this webinar on identifying intangibles. My name is Paul Sutton, and I'm one of the co-founders of LCN, and we specialize in the legal aspects of transfer pricing compliance. And our guest speaker is Donal O'Connell. Donal, I'll ask you to introduce yourself, maybe in a few words, but just to say for the benefit of the audience, Donal is absolutely the real deal when it comes to managing IP, because unlike many people who maybe have an academic understanding of IP, Donal has actually been at the coalface in organizations like Nokia in terms of creating and refining IP management strategies. So Donal, maybe you could give a few words about your background and how you came to be in IP.
Thanks, Paul, and thank you very much for inviting me today. Greatly appreciate it. So yeah, I've been involved in IP for over 20 years. I am not an attorney. My background's actually an engineer. I went up the traditional engineering career path, but then kept getting dragged into IP issues, either as an inventor, involved in disputes or whatever. So moved from being VP of R&D at Nokia across to director of IP, and ran Nokia's, what we nicknamed our patent factory, for about 7 years. So basically handling a large volume of inventive ideas and deciding which of those warranted to be patented. And patents were the main focus at that time. So we handled about 6,000 inventive ideas every year, filing about 1,500 patents per year for the 7 years I was director. 2009, I left, left and set up my own company, and I've been involved in IP in various ways, and since then doing some consultancy, doing a lot of education, and also having a small tech company that develops IP tools, supporting a variety of clients, probably over 200 projects in that time period. And sort of also expanded my own thinking about what IP is, and my views of IP have changed, I must admit, as well in that time period. But that's a quick background as to who I am and what my involvement with IP is.
Great. Thanks very much, Donal. And so the focus of this webinar is really about identifying intangibles, and especially from a transfer pricing perspective, because if you speak to TP advisors, then obviously they will be very familiar with DEMPE analysis in the context of IP. But what's really interesting about the OECD transfer pricing guidelines in terms of DEMPE analysis, it says, well, identify your transaction and then identify the categories of intangible assets associated with that transaction, identify the legal rights associated or attached to those categories of intangibles. But actually, there's no specific methodology about how you actually identify the intangibles in the first place. So really, that's the focus of this conversation. Donal, maybe you just want to briefly explain the graphic that we got on the screen here and what we'll dive into over the course of this conversation.
Okay. Well, the central part of the graphic we can delve into is about the fact that IP is not one thing. It's an umbrella term, and it's made up of different forms, different types. And yes, in the BEPS Action 8, it has listed certain types of IP it expects a company to manage as part of its tax compliance. So there are different forms, and each form is linked to a particular type of innovation or creativity, one could argue, and each form has their own oddities and idiosyncrasies. So you have to get your head around the fact that I need to understand what form are we talking about? Is it a patent? Is it a trademark? Is it a trade secret? And then understand what does that mean once you start delving in deeper. The box in the top right is referring to the fact that certain forms of IP are registered. You have to apply to the government to obtain those rights. You have to apply to the government to get a patent. You have to apply to the government to get a registered trademark. Other forms are not registered. So we will delve into the differences between registered and unregistered forms of IP and what that entails. The bottom left is referring to the fact that certain forms of IP are concentrated in certain corporate functions. Not always, but in general. So when we're talking about, for example, patents, often that's closely associated with the R&D function of a company. The trademarks might be closely associated with the marketing department. But there are other forms of IP that permeate the business. They're not in one place. And that causes interesting challenges when you're trying to identify them. Well, where are they? You've got to crawl through the organization to a degree. In the top right, one particular form of IP that is growing in importance from a legal perspective, but instantly is also listed as a form of IP in the Action 8 of the BEPS guidelines, is trade secrets and know-how. And that's an unregistered form, which means there's no patent office involved. And it definitely comes with its oddities and idiosyncrasies. So how do you go find the trade secrets in an organization, which we'll delve into? And last but not least, the bottom right is referring to, despite the best systems you may have in the world, every so often you just have to go talk to people and really interview them and be well prepared for those interviews to understand what information is coming back at you. So that's a brief journey or meander through that graphic, but we can delve into different parts. Absolutely.
Sure. Thank you. And one interesting thing that I find is that when you speak to tax directors, even transfer pricing professionals in relation to a particular company, it's not uncommon for them to say, well, we've got no intangibles, or we've got no material intangibles. Whereas from my perspective, if there's a difference between the enterprise value of a group and the sum of the value of its tangible assets, physical assets, and financial assets, that difference must be attributable by definition to intangible assets. And the question is identifying them. So I think part of the of the focus of this conversation is people will be very familiar with functional interviews for the purposes of TP functional analysis. The question is, in terms of the approach that someone like Donal would take, how might that need to be modified to actually get to the heart of what the intangibles actually are and what the group's strategy is in relation to those intangibles, so that the DEMPE analysis can actually be meaningful and accurate? So, Donald, should we start off and talk about registered IP, because that's maybe easier, as you said, you get the luxury of some kind of government register and a list of that. One of the really interesting things that you mentioned, actually, when we first met in Switzerland, is the fact that even with patents, for example, patents may be used in a very different way by different organizations in different contexts. And I know we didn't specifically prep for this, but could you explain that kind of difference in terms of what the strategy for a patent might be in different groups?
Yeah. Well, first of all, you're right. A patent is the registered form of IP, and it's a national right. So first of all, it starts life as an inventive idea, a solution to a problem that has a technical dimension. So we're talking about technical issues now. Hence the reason why most patents originate inside an R&D, because the R&D guys are people by their very nature, should be working on technical stuff. And if you believe you have an inventive idea that meets the criteria, that it's novel, it's non-obvious, etc., you may elect to apply for a patent. So you knock on the door of the government office responsible for patents. In the UK, that would be the UK Patent Office, or in most countries, it's either the Patent Office or the Patent and Trademark Office or the IP Office, and you apply. Roughly about 50% of the cases that get applied for end up with a successful patent. For various reasons, they get rejected. They either don't meet the criteria, or the company changed their mind, or they run out of money, or whatever. So you end up with a patent 2, 3, 4, 5 years after you applied for it. And it gives you this right. It gives you the right to stop anybody else using your inventive idea. It's a negative right in many ways. And there's records kept by the government that they granted. So Paul Sutton was granted a patent on the 26th of February, 2026 on this inventive idea. I suppose the advantage of a registered right is that there are records kept. So even if Paul decides, I'm not going to keep any records of my patents, the government does. Whichever law firm or IP firm you used to do all that application for, you will have some records. It is very difficult to end up with a collection of patents in Paul's company without somebody knowing what patents you have. There could be errors, admittedly. I'm not saying everything will be perfect, but at least you've got a starting point. You can go and quiz the public records about patents and see, Paul has 6 patents to his name. One was applied for in 2026. It relates to flux capacitor. Another relates to this, and so forth. So there are, at least it is in relative terms, I can do some searching using good search tools, patent search tools, and find out that Paul's company has patents. These are national rights. So Paul may have a patent in the UK, but he also may have the same patent in France or in Germany. So you've got to also look across the different jurisdictions to see where these patents have been assigned to Paul and his company. The same would apply, for example, to registered trademarks. There's a trademark office, there's records kept, and if you do the appropriate searches and sanity check, I can at least figure out that Paul has X amount of trademarks assigned to his company, maybe the home name, product name, or whatever. So the beauty with the registered forms of IP is that process ends up with records being kept, data about what assets belong to this company. I'm not saying it's 100% perfect because there can be mistakes made, or Paul could tell you he has a patent, but then when we check the records, we discover that Paul didn't pay the annual fees to keep it alive for the last 3 or 4 years, so that patent is gone. So he thought he had a patent, but he doesn't have a patent. Or Paul did some divestment of his company a couple of years ago. He thinks he has a patent, but actually, hey presto, that went off with the divested unit that was divested. So you have to do your appropriate checks to make sure that what really does Paul have as far as patents are concerned. Now, in patents are concentrated, by the way. So there are 15, 16 million patents active in the world today. 80 companies have about a quarter of them. And about 800 companies have about half of them. And about 80% of all the patents are in 5 patent offices. So not every company will have patents. It's not that everybody out there has a patent. They tend to very much be concentrated in certain industries, CT, pharma, and so forth. And like I said, there are certain companies who are really aggressive in using patents, but there are lots of companies out there who have no patents. It doesn't mean that they have no intangible assets. They just don't have that particular form of IP. And like I said, they may have patents, but they're in the US, China, Japan, Korea, but they're not in, I don't mean to be disrespectful, they're not in Namibia or in Ireland or in Iceland, because companies don't tend to have patents everywhere. Particularly in the ICT sector, you tend to see patents concentrated in the G7 type countries. Pharma is a little bit different. You have patents in many exotic parts of the world. So a company will not just have a patent in their home country, they'll have it everywhere to protect their invention. So the way patents are used differs greatly by industry sector. So the second part of your question is, how are patents being utilized? In pharma, they're often used as a defensive shield. I want to protect and keep exclusive my inventiveness. I have invented this blockbuster drug. I have spent a fortune developing it and testing it and so forth. I want to be solely have the right to make this blockbuster drug. I don't want you to come along or my competitors come along and duplicate or copy what I've done. So you see patents used very much as a sword to go attack and say, hang on, stop, you can't do that. In the ICT sector, it's a little bit more viewed as these are assets. So I might allow you to use some of my patents, but in return, I want to use some of your patents. So there's a more of a swapping or a sharing or a cross-licensing of patents in, let's say, the ICT and telecoms industries. Not always, but it's a little bit more viewed as an asset that can be leveraged in a different way. I'm not always using it as a sword. I'm sometimes using it as a way to open doors and establish relationships and so forth. So how you use the patent will depend on your IP strategy. And like I said, in certain industries, there's a certain type of way we expect the game to be played. You don't have to follow those rules, but in general, the way patents are used in the ICT sector will differ from the way patents in general are used in the pharma sector or whatever.
So is that right? So thinking about products like smartphones, that a given smartphone might use hundreds of patents under license from different owners. Is that how it works?
Oh, in a smartphone, there are north of 10,000 patents that describe different inventions within a smartphone. No one company owns all of them. So my old company, Nokia, would have some of them, but Samsung, Apple, Huawei, etc. So if you decide tomorrow morning to open up a new company making smartphone technology or making smartphones, one of your challenges, first of all, is actually there's a lot of patents out there already, meaning those people have exclusive right to those inventions. So you'd have to have an interesting discussion with lots of people to see if I could license their patents to allow me to bring a product to market that doesn't infringe on their rights. In
Yeah.
comparison, a blockbuster drug by a pharma company might have 3 or 4 patents protecting it. So you take
I
2 products, a smartphone,
sorry.
10,000, a drug, 3 or 4.
Interesting. And one of the other features of patents, which I think is very interesting, is it's not often appreciated, is you might think that you have the registered patent and it has been maintained, the renewal fees have been paid, but actually it might be vulnerable to challenge because of prior art or because the underlying inventive step has actually been disclosed to the public inadvertently prior to the application. And that meant that if anyone wants to do some digging, they can actually come along and invalidate the patent.
Well, that's possible. I mean, so when you knock on the door of the patent office and apply for a patent, the examiner at the patent office will do various searches and checks before they turn around and grant you the patent. Hence the reason it takes them 2, 3, 4, 5 years to come back with an answer to say, yes, I think Paul deserves a granted patent. They are checking to see, first of all, the obvious thing is your idea novel? Are you the first person, Paul, to come up with this inventive idea? Because if somebody else has already come up with it, either published it, or it's already in a patent, or it's out there in a product in the marketplace, then you're not novel, you're not first. And if you're not first, you can't get a patent. Now, the danger is that the examiner does a search and fails to read a specific manuscript written in Hungarian, locked away in the back of a dusty old library, and he misses that prior art. So he turns on to you, Paul, after 2 or 3 years and goes, Paul, I think you're first. Nobody else has invented this idea. This is the best flux capacitor we've ever seen. We've never seen anything like it. And you get a patent. But then later on, someone digs out that manuscript and suddenly realizes, Paul, you weren't first.
Mm-hmm.
Somebody in Hungary came up with the exact same idea before you and wrote about it. But it was missed by the examiner. Your patent can be invalidated because it wasn't novel.
Right.
To be novel, you have to be first. And if somebody else is first before you, you're then second, which means, yes, there's always a risk that your patent gets beaten up later on. There's certain processes, depending on the patent office, as to how you go about it. And it differs a little bit by jurisdiction. The process is different, let's say, in Europe compared to the US. But yes, there's a possibility that your patent gets killed basically because there was a mistake made, either like the example I gave you there, or worst case, which often happens as well, is that, Paul, you came to the patent office claiming that you have this inventive idea and you went through the process, but you yourself opened your mouth a couple of months before you knocked on the door of the patent office, and you stood up at a conference and you had a lovely PowerPoint presentation about this inventive flux capacitor, and you created prior art, which sometimes happens that the inventor themselves, by talking about it openly, actually kills their own patent application.
Mm-hmm.
Or there could be other reasons. It could be, Paul, you went to the patent office claiming you were the inventor, but actually you weren't the inventor. The guy sitting next to you was the inventor, and you just happened to listen to his idea and you took it and pretended. So there can be various reasons why your patent could be invalidated. Like you yourself created prior art, somebody else has prior art that was missed, or you made a mistake somewhere or whatever, or there was a dispute about inventorship or whatever. And that does happen to the patent world. And there's a fairly well-defined process as if that was to be the case, as to how would you go about challenging Paul's patent to invalidate it or whatever. Right. And like I said, it could also be that you didn't do the admin work, you didn't pay your fees, and the patent expired because you were meant to pay the government a fee to keep it alive, and you failed to do it. And time has progressed, and you still think you have a patent, but actually it died a couple of years ago.
Yeah, and just to take that point, I mean, obviously we don't give TP advice ourselves, but we come across instances where this kind of thing has actually had teeth. So, for example, we've heard that the China tax authorities are very diligent in actually checking patent registrations, trademark registrations in the context of intercompany transactions and transfer pricing to check, are those registrations still valid? If they're not, and yet those registrations were the subject of license fees, then there would be an adjustment made, or that deduction would be denied from a corporation tax perspective or whatever. So this is not just a theoretical point; it is fundamental
Oh
to
yeah, yeah.
housekeeping.
And
From
I've worked with companies where that we have found errors in in the data they have about their registered IP. You think it's perfectly set as there was a mistake, make there, or human error, or whatever. So it can happen. So I'm not surprised that's the comment you made about a particular tax office saying, well, we're going to check, because you can find things amiss, no doubt about it.
yeah.
But at least you've got a starting point. You've got a list of your patents or your trade secrets. It gets much more challenging when you start moving across to the unregistered.
Absolutely. And just at this point, I can see we've got two questions. One is easy to answer. Where can I access the recorded version of this webinar? Thank you for asking that question. So we will circulate a link to the recording after the event. So please feel free to share it with anyone of your colleagues or that you know who couldn't make it and would have liked to. And then the other question is maybe a segue to a discussion about other forms of IP. So could domain names be considered as IP? Does that give some kind of a competitive advantage to businesses?
Well, with my IP hat on, I definitely see domain names as an intangible asset. It's your unique address on the World Wide Web or the internet. It's an intangible asset. Now, the value it brings can vary from one company to another, but there have been cases of domain names. I mean, normally you're paying whatever it is, £20 a year to keep your domain name alive with the local domain name registrar. But there have been cases of companies failing to do it and suddenly having somebody else coming along and, in a sense, having your domain name. You're thinking, I need apple.com. And I'm Apple, and suddenly realizing, Joe Bloggs down the street has paid the £20 to get my domain name. So there have been examples of very expensive transactions involving domain names. Now, does everybody in IP view it as a form of IP? Some IP, probably perfectionists think, no, IP is patents and trademarks. And domain names aren't government controlled; they're controlled by somebody else. But in my view, it's a form of intangible asset. It's an intangible asset, and it requires thinking about what assets you want. You have to pay a fee to keep it alive. And in some cases, for some businesses, your website is one of the most important things in terms of your interaction with your clients. And if you don't have the domain name to go with that website, then you're stumped a little bit. So I would argue yes, but there can be people who would disagree with me on that one.
Yeah. I mean, and certainly from an OECD perspective, as you know, the definition of intangibles is incredibly broad. And so it would certainly include domain names, social media handles, all that kind of stuff. And then it becomes a question as to identifying them and identifying their economic significance, I guess, to the group, to the company involved.
Yep.
Maybe we can just segue to the top right, so the trade secret and know-how side of things, and just to add a bit of context. Certainly, one thing that we're seeing more and more in terms of the transfer pricing policies of multinational groups is that we're seeing more and more process type IP. In other words, the group's particular way of doing things being specifically captured and remunerated as a quasi intra-group franchise type arrangement. In other words, there's a particular way that the group has to do things. You know, maybe thinking about Starbucks, they got a particular way for running the coffee shops, or McDonald's is a classic example, and therefore making that available to different operating entities needs to be remunerated. And we're seeing that more and more being captured and priced specifically. So Donal, obviously this is a broad subject, but if you're thinking about you're going into a client for the first time and you're helping them to get a handle on what are they actually got in terms of trade secrets and know-how and confidential information, how do you help them to unbundle all of that and get clarity on what they've got?
Okay. Well, confidential information, know-how, and trade secrets are all unregistered forms of IP. So you don't have the luxury now of going and knocking on the government office and say, can you tell me what trade secrets Paul's company has, or what confidential information? Because the government will say, we don't know. You got to go talk to Paul about that. Now let's break it down. So sometimes these words are used interchangeably, as if confidential information, trade secrets, and know-how is the same thing. But I would argue to be very careful there. They're not the same thing. They're very similar, but there are differences, some subtle and not so subtle differences. So let's start with one. So first of all, trade secrets. So trade secrets is any business information that meets 3 requirements. First of all, it is secret. It is secret. I can't read about it in the New York Times or do a Google search. It's secret. It adds value to the business. The fact that the business has this information, gives it some competitive advantage in some way, shape, or form. And thirdly, the company must actively take steps to protect it. Just saying it's secret isn't good enough. You've got to be able to articulate, what have you actually done to protect it? Have you limited access? Have you encrypted it? Have you hidden it behind a firewall? Is it locked in a safe, etc.? Now, trade secrets in the world of IP were not seen as that important until about 2016. They weren't. If I look back at my own history in Nokia, patents were the most important thing. Trade secrets, why? Why would we be interested in it? It's not seen as that important in the world of IP. The law isn't that clear and yada, yada, yada. And between 2016 and 2018, we had dramatic changes because the law changed. It changed in key jurisdictions. You had federal law in the US in 2016, the Defend Trade Secrets Act. You had the European Directive on Trade Secrets passed by the Commission in 2016, enacted by European states in 2018, about 2 or 3 weeks after GDPR. GDPR took all the spotlight, but people forget that there was also a major law, which was the European Directive on Trade Secrets. China, which has had trade secret laws, their big one being the Anti-Unfair Competition Act, they enhanced it greatly in 2018. Again, in 2019, they made some more changes. You had Japan changing the law as well. So in a very short period of time, the law changed dramatically. And what it did was, first of all, it clarified the definition. This is what we mean by a trade secret. It clarified what it was protecting, which was the theft or the misappropriation of a trade secret by somebody, an employee, a third party, a competitor, whatever. It increased the penalties, and in some jurisdictions, it's criminal law. So you can go to prison for trade secret theft. Patent infringement, you get a slap on the wrist, and you might have to pay some money. You don't go end up in prison. I mean, as we're talking here today, there are people in prison for trade secret theft. That's how serious it is. And which resulted then in many trade secret disputes, so the number of trade secrets disputes are increasing. The valuation of trade secrets increased. We see that from, for example, third-party comparable data. We see it from the court case awards. So suddenly trade secrets became sexy in the world of IP. And as I joked with Paul a couple of times already, previous conversations, IP isn't generally sexy, but trade secrets have suddenly become really interesting. It's also intriguing that in the BEPS article, Action 8, where they define examples of intangible assets, they specifically say trade secrets, which means the tax authorities are also expecting you to manage your trade secrets. But the downside is there's no registration. You've got to keep your own records. You can't go to the government and say, tell me, can you list for me the 10 trade secrets I have? They go, we have no idea. Now, the world of IP doesn't work that fast generally. So what's happening at the moment is lots of companies are just slowly waking up to the fact that trade secrets have changed. Before 2016, they weren't paying any attention. Now they're beginning to pay attention. And some companies are beginning to realize, well, wouldn't it be really useful if I had some sort of central register where I identified what are my trade secrets? Because how can I look after them and protect them and keep them secret, et cetera, if I don't even know what they are? So one challenge facing the tax folks is that when they go and quiz a company saying, do you have trade secrets? You'll probably get a sort of an answer which is, oh yeah, of course. Don't tell me now you're going to ask me what they are because I don't know. But of course we have them. They must be here somewhere. And that's the challenge, because a lot of companies are only beginning to take their first baby steps trying to figure out, okay, I've got to, in a sense, act like my own IP office. I've got to keep my own records. And some companies will have no records. Some companies will have minimal set of records, and a few companies will have very good records, which means then if you're dealing with a company that doesn't have good records, what do you do? A couple of things you got to go back and first of all understand the definition is, does the company have information which is secret, adds value, and if they've taken reasonable steps? And we do a lot of work in this area. What we've said is, if you go to a company, if I go to, so I'm sorry to pick on Paul's company. So I go to Paul and say, Paul, do you have trade secrets? And he might say, well, I do. I'm not sure. I don't know. And what you want to do is go beyond that conversation to say to Paul, well, do you have any of the following? And what we have developed is suggestions list organized by corporate function. So if we're talking to, for example, the R&D manager in Paul's company, we'll say, well, do you have CAD drawings, technical processes, test data, yada, 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 the stuff that you might see permeating an R&D function? And if they say yes, you go, okay, so you have some CAD drawings. Are they secret? Or have you published them widely? Because if they fail the first test, they're not a trade secret. They say, oh yeah, we keep these stuff secret. This is very important to us. Do they add value to your business? Oh yes, because we've spent a fortune developing this stuff. We have engineers working on this stuff for months and months and months. These are extremely valuable. And do you protect them? Well, they're encrypted on the network, et cetera, et cetera. So now you go, now I think you've got a trade secret.
Mm-hmm.
The questions you're going to ask of the marketing people are going to be different. You're not going to ask them, do you have CAD drawings or test scripts? It's going to be, do you have client databases? Do you have a client database with details about all your clients? Do you have financial information that you think is secret and so forth? Do you have marketing plans? Do you have competitor intelligence, et cetera, et cetera? When you go to the factory manager, you're going to ask a different set of questions. Do you have a production process that's quite unique and novel? Do you have test scripts in your production test equipment? Do you have information about your parts suppliers, et cetera, et cetera? So in many cases, what you're having to do is sit down with the client and in a sense, help them create their register of trade secrets. You might be looking, they say, hey, you don't have to ask, we have them already. But that's going to be very few and far between because with trade secrets, we're in a very early stage of companies taking it seriously because the law has only recently changed and companies are waking up to the fact that, we've now got to focus on this. So the reason why companies are doing these registers isn't for tax reasons, by the way. It's because of the number of trade secret disputes that are taking place. So I don't want to go to court and say, trust me, Your Honor, this trade secret was the most valuable asset we have and that guy over there stole it. And then the defense lawyers will go, hang on a second, you say you've got these really valuable assets. Do you maintain a central register? Oh, no. How many trade secrets do you have? I've no idea. It doesn't look good in court if you don't have a good story to tell about how you're looking after these really valuable assets. So the requirement for a register is being driven because of the litigious nature of trade secrets at the moment. But of course, once you have the register, it also helps you with the conversations with your tax guy, your tax advisor, your tax director, or whatever. But
and Donal,
like I said,
how would you?
Sorry, go ahead.
How would you describe the interface or the relationship between trade secrets and know-how? Is it just that know-how may be protected or may be protected as a trade secret by confidentiality? But what is the relation?
The problem is a little bit in which jurisdiction we're talking about. In certain jurisdictions, trade secret laws are a bit fuzzy still, and they don't distinguish between trade secrets and know-how. In my mind, I see a difference in that. So a trade secret, first of all, is documented. It exists in the company. It's a CAD drawing. It's a client list in that file. It's whatever. Know-how is in the head of the employee. And the challenge, of course, is the head of the employee. Take my brain. So I've got certain information in my head that's know-how, but it's completely useless. Like the cricket scores for Durham Cricket Club for the last 100 years. Now, I might think it's very useful information, but as far as the company is concerned, that is useless information. So some know-how would never qualify as a trade secret. But there might be stuff in my head that is really valuable to Paul's company because I am the operator of a specific piece of test equipment, and I know how to configure it, set it up, yada, yada, yada. So some of the know-how in your employees' heads actually comes very close to being a trade secret. And in certain jurisdictions, they'll treat it as a trade secret. In other jurisdictions, they'll say, is it documented? Has Donal actually written down the way he configures this piece of test equipment? So it varies by jurisdiction as to whether know-how or some know-how in the employees' heads qualifies as a trade secret. Then if we come back to the other thing we talked about, confidential information. So you can have confidential information. So all trade secrets are confidential information, but not all confidential information is a trade secret. So, Paul, you're the CEO in this very innovative company, and you decide that you don't want people ringing you out of the blue, so you tell your assistant that your direct telephone number is to be kept confidential. If they want to ring you, they got to phone the receptionist. Now, the fact that you've decided to keep your direct telephone number confidential does not suddenly make that telephone number a trade secret. Any CEO of any company can keep their telephone number secret. It doesn't give you a competitive advantage. It saves you getting annoying phone calls, but it's not a trade secret. Some confidential information is a trade secret, but some, it's just a confidential information. It doesn't give you a competitive, it doesn't add any value to your business over anybody else. The fact that you've decided to tell your assistant or whatever to not divulge widely your telephone number. So you've got to be a little bit careful that confidential information, trade secrets are confidential, but it doesn't mean the reverse, that every piece of confidential information in the company qualifies as a trade secret. So there are subtle and not so subtle differences between confidential information, trade secrets, and know-how. What I like to do is, if I am tasked to go crawl through an organization, start off by making sure that everybody's clear as to what are we talking about? What's the definition we're using today? I like to focus in on trade secrets and then catch certain confidential information and challenge them to say, you're telling me this information, but is it really a trade secret? How does it add value to your business? And then you sort of push aside certain confidential information. You go, well, okay, the telephone number is nice, but I'm not going to put it on the register. And then the know-how is, okay, is it the Durham Cricket Club scores? Yes, it might be know-how, but it's no value to the business. But if it's the know-how about how to configure this piece of test equipment, now I put it into the register. And of course, some companies will say, well, actually, maybe we need to capture this stuff because having it just in existing, and Donal said, is not a very safe means. Maybe if he get hit by a bus tomorrow morning, we've lost that information. So there's a bit of dynamic play when you're trying to crawl through an organization. One other point I should make is back to the point about the conversations. Trade secrets, remember in the definition, I said, if it's secret, it has value, you've taken reasonable steps. I did not say it needs to be technical. So about half trade secrets aren't going to be technical. Client lists, supplier data, financial information. So the challenge with trade secrets is A, they're not registered. B, there's this fuzziness between know-how, trade secrets, and confidential information. But thirdly, they permeate the company. They're not going to be found in one place. There'll be trade secrets in your R&D. There'll be trade secrets in your marketing. There'll be trade secrets in production. There'll be trade secrets in sales. There'll be trade secrets in service department, which is one of the other challenges because it means that you have to go and have a conversation with different corporate representatives. And for some of those corporate representatives, they have never had an IP conversation before. So you're probably the first person talking to them about IP because whereas with R&D, they're used to having a conversation about IP because that's about patents and so forth. The marketing people are used to having a conversation because it's about trademarks. But the head of service department, if you suddenly have a conversation about IP, he's going, what's this all about? Why are you quizzing me about what knowledge is in the head of my people or what process we have or whatever? Because you'll likely be the first person having that conversation.
Right.
So trade secrets pose an interesting challenge.
So we got this distinction between trade secrets and confidential information. And then we've got the kind of broad category of know-how, which may or may not be reduced to some kind of tangible form. It may or may not be capable of being the subject of a trade secret. And I guess when you're going into a company, Donal, you're doing it from the perspective of helping them to identify and protect what they genuinely care about in order to preserve their position in the market and maybe to prepare for exit or investments or whatever, but actually to produce an economic advantage for them by utilizing or managing their IP and their know-how better and making it protectable. Is that a fair?
Yes. And there are, like I said, there are multiple advantages in knowing what trade secrets you have. One example is just to show you and to highlight the fact that there's these forms of IP aren't islands. There are connections between one form of IP and another, and there are connections between patents and trade secrets. So, for example, let's say we're two companies, Paul, and my company comes up with this really interesting idea, and we decide to keep it a secret. So we have developed, we've developed this new concept called the chair, never been invented before. 4 legs, a seat, a backrest, saves you when you're tired and so forth. So we have it, but we keep it secret inside in our building. Nobody else knows we have it. Later on, you come up with the exact same idea, completely independent of me. And you say, wouldn't it be great if we developed this idea, 4 legs, a chair, backrest, and so forth? But you decide to patent it. So you go to the patent office saying, I've invented a chair. I don't think anyone's ever thought of this before. Patent office is amazed at this ingenuity and they grant you a patent. So now you have a patent and I have the same idea as a trade secret in my building. Perfectly reasonable. That happens. But now for some reason you discover or you suspect that I might have a chair in my building. So you knock on my door with your patent and you say, Donal, you've got to stop. You infringe my patent. And I say, no, Paul, I don't, because I've got prior user rights. I have evidence that I had my chair in use before you knocked on the door of the patent office. Now, in such a case, I've got to prove that I had the chair in use before you applied for so I've got to have records. One reason why it's good to have a trade secret register, because I can't go to court and say, trust me, Your Honor, of course we had this chair before Paul came up with the idea. The judge is going to prove it done. Now, I don't know about you. I can barely remember what I did last weekend. If I've got no records of when we came up with the idea of the chair, when we first made our chair, when we first of all put it into that production plant or whatever, I'm going to lose that case and I'm going to end up infringing your patent. But if I've got good records, I will win that case.
Mm-hmm.
So there are various reasons why I want my clients, forget tax, why from an IP point of view, why I want them to have good records of their trade secrets. One is if I get involved in a trade secret dispute, I want to show the court that I take these assets extremely seriously. And I have, just like I might have a tangible asset register of the physical assets in the company, I also have an intangible asset register, including my valuable trade secrets. I don't want to go to court and say, I don't know what trade secrets we have, but they're all valuable. I don't know where they are in the company, but they're all valuable. I don't know who's got access, but they're all valuable. That doesn't come across as a good story. Whereas if I can go to court and say, I take this stuff extremely seriously, I recognize they're not registered, so I myself maintain a register of my trade secrets. Secondly, in the event of you knocking on the door claiming to have a patent, I can use it to help me with prior use rights. But also, as you hinted on there, if my company goes to any corporate event like an investment round, a merger and acquisition, a joint venture project, and there's somebody doing due diligence on me, having these records puts me in a very nice position. I go, well, you want to see what record keeping we have about this is what we have. Because IP does come up in lots of those corporate type events. If an investor, if I say, actually, I've got all these valuable trade secrets, and the investor goes, well, by the way, do you know what you have? I've no idea what I have. No idea. The investor isn't going to look at me very favorably. He's going to go, you don't come across as an organized guy when you tell me you got all these valuable assets, but you don't even know what you have or where they are or what parts of the business they relate to, whatever. Whereas if I say, no, I've got an essential register. So there are various reasons. Now, obviously, I am extremely interested in where the tax authorities are viewing things. So I also am now aware that actually having this register helps me if I have to have a conversation between the IP manager and the tax director or their tax advisor or their transfer pricing advisor, because I now can have a conversation to say, these are the trade secrets we have. These ones are originate in our R&D department. These ones are in our factory. These ones were created in this part of the business, but they're used in this part of the business, etc., etc.
And I guess what this means, obviously, we're having this conversation in the context of a transfer pricing audience, if you like, and what you're talking about, Donal, is really the overarching recommendation or necessity of groups having a clear handle on their different categories of IP and having a clear intentional strategy as to how they defend and protect and maintain that IP for the purposes of the group. So there's that kind of intention there. And obviously what we're aiming at overall is an alignment of substance between the way that the business genuinely works, the way that it manages IP, and that being properly managed and documented for all the reasons that you've just explained, and for the transfer pricing and tax explanation of how the group works to be consistent with that reality and the genuine economic value and economic necessity to manage those assets. So that's what we're kind of driving for together, isn't it?
Yeah. However, let's be brutally honest, most IP managers, so if their company does have an IP department or an IP function responsible, most IP people, their level of understanding and appreciation of transfer pricing and BEPS and intergroup licenses is very poor, because historically IP has been sort of the sword or the shield. So you tend to be looking outside. You're looking at your competitors or your suppliers. You're not looking at, well, this part of the group, the R&D function in the UK and the production facility in France or the sales office in Germany. You don't tend to spend too much time thinking about, well, hang on, how does this IP relate to the relationship between group members? That's not in the DNA of an IP manager, because typically I'm worried about, am I using this patent against that competitor, or am I licensing this IP to that supplier or whatever. So there is quite a journey for a lot of IP people to go through to suddenly realize actually there's a new dimension I've got to think about now, and that is how is actually IP used within the group, and that is
Yeah.
that is an interesting challenge because if you look at a lot of, for example, the records kept within the IP department, regardless of whether it is registered or unregistered, most IP systems aren't recording that. Also, most IP departments are not involved in the drafting of intergroup license arrangements. That's typically handled by the legal department together with the tax people. The IP people, they might be very good at telling you about what IP licenses they have arrangements with, they have with a key supplier or a competitor or whatever, because that's part of their day-to-day work. But, I know a lot of IP people inside in-house or in the advisory side of the business, and I say to them, talk to me about how your involvement in intergroup licenses. And they go, I don't really get involved in that, Donald.
Right.
Which is
Right.
somewhat worrying, I must say.
Indeed, yeah. Which means that it is a governance challenge and an operational challenge to identify the IP or the different categories of IP or intangibles, how it's used by the group, its strategies for using it and protecting it and developing it, and then map that onto the group structure in such a way that it can be accurately reflected in intercompany agreements, including licensing agreements, and it can be accurately described in the DEMPE analysis in a way that makes sense overall. I just want to come back to know-how, because I think that this is so. If you look at the OECD definition of intangibles, it's essentially anything that is not a physical asset or a financial asset, the use of which or the purchase of which would be remunerated between unconnected third parties. Okay, so that's the extremely broad definition, and clearly that would include domain names and social media handles, and in many cases it would also include know-how, even if that know-how didn't have the characteristics of a trade secret which could be litigated in that way. So what is an appropriate way, from your perspective, Donal, on getting a handle on that category of IP?
Well, again, we go back to the suggestions list approach that if you go if you're quizzing a functional manager about what know-how exists in this part of the business, and you go in with a blank sheet of paper, you're likely to get a strange answer, thinking, well, I'm not sure what you're looking for because I have no reference point. Whereas if you go in and say, well, do you have any of the following? And then, of course, you can build upon it and so forth. And then once they say, oh yeah, we have this information, then the follow-up question is it documented or not? Does it exist in a tangible form? It's in that file or whatever. Or is it just in the heads of employees? And if they say it's not documented, then you're down to, okay, now we're into know-how. And then there's sort of three questions. Is this know-how, explain to me how it adds value to the business? How does this person having this know-how add value to the business? And again, you can have a sort of prompt sheet to say, well, does this know-how mean we can run our factory more efficiently than our competitors? Can we save energy? Can we reduce headcount? So you can give them maybe a dozen different, say, does it give us a benefit in any of these areas? Or then obviously they always have to have an open question at the end. Or is there something else you want to add in and so forth? So what you're trying to do is identify the know-how that exists inside in a team or a function or a group of people that you can clearly say, yes, it is know-how because it adds value to the business in this way, and then record that onto your register. So it's in the form of know-how. It relates to those four operators because they're able to configure and set up and configure this machine more effectively than anybody else. And we've had this advantage since XYZ period or whatever. And where does it exist? It exists in that plant. Has it ever been transferred anywhere else then? Has it, those four guys also help set up the same equipment in sister factories in other countries? You find, okay. So it allows you to have that conversation. But I suppose from an IP hat on, I would always then ask the question saying, are you comfortable with the fact it's not documented? Do you need to take an action now to say, let's capture it? And we see that happening in companies where they do this exercise and then they go, actually, we now need to either get the people themselves to document it, I know one software company, when they identify know-how, they interview the engineer on camera. So their form of documentation is video. They basically interview the guy to say, well, you configure that piece of machinery. Explain to me what you do. And he answers the question. They go, fine. We have it now. We have a record of that conversation. So it suddenly becomes, because a trade secret doesn't say how it should be documented. It doesn't say it has to be in Word or PDF. Any form is good enough. So, but that may be separate from a tax discussion, because in the IP world, having really valuable know-how that's never been captured is a risk, because God forbid those guys get hit by a bus tomorrow, or they retire, or they walk out the door and join a competitor. You can't tell the employee who's leaving to leave their brain behind. They take it with them. And suddenly that asset doesn't belong to the company anymore.
Yeah, absolutely. I'm just conscious that we are unfortunately coming up to, I think we've got 4 or 5 minutes left, and I'd just like to attempt to wrap up the conversation. And please, Donald, correct me if I've got anything wrong or if you would add anything. So I guess what one key takeaway is, obviously, it's not just about registered IP. That's a starting point. That's a question to ask and is easily capturable. But even with registered IP, it's not just what are the registrations, it's also understanding how that IP is actually used in the group, because there can be different strategies for a particular category of IP actually being used. So that's one point. The second point, in terms of like the wider capturing of intangible assets, which includes the know-how and trade secrets conversation, and we haven't even got into copyrights and so on. From my perspective, it's just that awareness that, as you said, Donald, it's not enough to ask people, do you have any intangibles? Because they'll say, unless they're an R&D team or a patents team, they'll probably say, what do you mean? And so it does, I think, require more targeted questions of the right people, giving the appropriate suggestions or prompts until you come away with an accurate explanation of, this is how the group actually works, and this is what is attributable to the enterprise value or the profit potential of the group as a whole. And it's only by doing that deeper dive that you can really get a handle on what the intangibles picture is. And then comes in the, well, how does that map against the legal entities, and how does that map in terms of DEMPE analysis and so on?
I agree with that last comment. I think you've got to be a little bit like that Detective Columbo on the TV program many years ago. You got to have this ability to quiz the client and dig. Like, for example, if I give an example, so we did a trade secret harvesting exercise or identification exercise with a company who make an automotive part some time ago. And our strategy was, so we had the register open, we had a room booked for the day, and we basically asked about a dozen key contributors in a certain department, say, could we have 15 minutes of your time, each of you, one at a time? We didn't want them all in group session. He said, we'll take one of you, and then 15 minutes, we'll rotate you through. So the question to the first person was, we said, okay, here's the suggestion list. There might have been 30 items on it that related to that particular type of activity. We said, do you have any of this stuff that you're aware of inside in the group you work for? And the guy went through it and went, oh, yeah, we have these CAD drawings, we have that, and we have that. We said, fine. What do you call, just so now, because this is very general, what do you call specifically? So we created version 1 of the register based on one interview and maybe identified 5 or 6 items. Then we got the second guy to come in and we said, okay, we're going to ask you the exact same questions. But then we did something else with the second guy. We showed him the 5 items that had been identified by the first guy and say, did you agree? Because your previous colleague identified this other stuff as well. Can you comment? Do you have any comment to make? Are you familiar with it? Now, the second guy went back and said, well, the first 2 items I'm not familiar with because that guy's a slightly different skill set than I. So I'll take your word. I'll take his word for him that he's that. But this other thing, he said, we've got this stuff. And he's claiming it's a trade secret. But that's been patented by us. Now, obviously, if it's patented, it's published. So we went, okay, question mark, big question mark now behind, because 2 people are telling us the opposite. One guy's telling us it's a secret, and the other guy's telling us it may have been a secret, but we switched it to a patent. And we did that for the whole day. And suddenly you'd find that what you do at the end of the full days, you now have a fairly good register because it's been critiqued. It's been challenged. You have identified areas where you're getting different views, but you can now challenge them to say, well, is it a secret or did we patent it? If we patent it, can we see the patent, please? Can we cross-reference to say, that's no longer a trade secret. That became a patent. Or some guy might say it's a secret. And then someone else will say, but we share that with the university. We go, why did you share with the university? Because we're doing some research with them. Was it under an NDA? Not sure. Did the researcher at the university publish about it? He probably did. Can we cross-reference it? So it's this, you have to sort of have a systematic approach, because in many cases, like you said, you're starting off with a blank sheet of paper. You may be very fortunate, and the client turns around to you and goes, here's my register of trade secrets. But in today, 2026, that's not going to happen very often. So you're going to have this approach of, can we interview key people and start building up an internal register of our trade secrets and know. And of course, one of the questions will be, is it documented or not? And that's it. That's then pushing you to either classify it as a trade secret or as know-how. And once you've done it, that's not the end. You may have to do this every year. I mean, things change. A company might change spots, divest. So this isn't, you can't just sit in your backside and say, oh, we've done it now. That's our list for the rest of eternity. It will change.
Yeah, absolutely, Donald. And I think that the risk is, well, this may sound like a lot of work, although I'm sure it can be adapted and scaled up or down according to the size of the organization. But the risk is that if that hasn't happened, given that intangibles probably account for 90% of the value of any given group, if that analysis of intangibles has not happened, then what confidence could anyone have as to the transfer pricing policies if the master file just says we've got patents or there's no material intangibles? It really potentially invalidates the whole of that economic analysis, unfortunately. So which is the negative note.
Yeah, it has serious implications. I mean, and not for tax. I mean, if you're a director and officer of a company, you've got a fiduciary duty to look after and care for the assets of the company, and trade secrets may be the most valuable assets you possess. We talked about trade secret legal cases. You may find yourself in court and it doesn't look good if you say, well, actually, we have no idea what we have. Yes, there are potential tax issues where you're not managing, you're really not compliant with BEPS and the sort of thing. You may be going to a corporate event like an M&A or a joint venture, whatever, and suddenly during the due diligence, you don't look so good because the other party suddenly spots that these guys have no idea, have no way of managing these really valuable assets. And that's what's valuable about the company. And yet they don't seem to be caring for it. And of course, not all of the trade secrets in your company may be yours. Remember, a certain percentage of the trade secrets in your company belong to somebody else. They belong to your key suppliers, your collaboration partners, your customers. And you've signed NDAs with these companies promising that you're going to look after these assets with tender, loving care. Because that's what an NDA is, after all. You're going to be giving something really confidential, and you're expected to look after it. Well, if you don't even maintain a list of what you have, how can you turn around and claim I'm looking after it? Well, I don't even know what I'm looking after. So there can be lots of implications, adverse implications to a company that don't look after their trade secrets and know-how. And I think precedent there with tangible assets. Well, one component of looking after it is, do you have a register of what you have? Because if you don't know what you have, then that's not a really good indication that you're looking after it well.
Exactly. Which I think is probably a great note to end this on. Unfortunately, we've run out of time. Thank you so much, Donal. Hopefully everyone who's tuned into this or has listened to the recording has found it valuable. If you do have any comments, questions, suggestions, please do reach out. And I'm sure, Donal will be catching up soon, I hope, and we'd be delighted to respond and share our thoughts as well. So thank you again, Donal. Thank you again, everyone, for listening, and look forward to the next time. Thank you.
Thank you.